I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Today, we are discussing a rule issued by the United States Department of Justice that is designed to limit how foreign countries may be able to access certain types of US personal data. Some of that data, in fact, is exchanged in everyday transactions. This is the DOJ's Data Security Program, which on this episode we might refer to as the DSP. It is also sometimes referred to as the DOJ Bulk Data Rule, which, for reasons that we may get into, is not really an accurate description. The DSP, which went into effect in April of 2025, aims to protect data from a national security perspective. It does so by restricting and in some cases prohibiting US companies from engaging in what is called covered data transactions with, quote, certain countries of concern. There's a lot of jargon here. We'll help you sort through all of it, figure out what makes sense. But this episode is really designed to help you understand what the current DSP landscape looks like, to signpost enforcement risks, and to provide you with some practical views about how you might be able to carry your organization's efforts into compliance. We have done a few episodes on the DSP earlier this year, but it's so big, it's so important, and there are so many things going on that we thought it's time to revisit, especially because the second phase of the requirements, those that focus on the documented compliance program requirements, mandatory reporting, and required auditing and other governance, just went into effect a few weeks ago. Before diving into where we stand, I just wanted to give you maybe a 1-minute breakdown of what the rule is and when it applies. So here it goes. DSP regulates US data transactions with 6 countries of concern. These are China, including Hong Kong and Macau, Cuba, Iran, North Korea, Russia, and Venezuela, all with certain covered persons that are affiliated with those jurisdictions. These are companies that are established in these countries of concern or individuals who primarily reside in those countries. And the rule is concerned with 2 different types of data access. Access to government-related information about its personnel, and access to bulk quantities of, quote, sensitive data, which could include things that are traditionally sensitive, like genomic, biometric, location, health data, but also, frankly, a lot of other types of data, which has historically not been considered sensitive, things like contact and device data. The DSP prohibits 2 different types of transactions. First, it prohibits data brokerage transactions with covered persons and with foreign persons unless there are contractual safeguards that prohibit onward transfers to those covered persons. Second, the DSP prohibits transactions that involve covered access to bulk genomic data or other types of data that is considered nomic data under the rule. Those prohibited transactions are just banned. They are prohibited from here on out unless they are separately licensed or exempt. And then importantly, we have another set of transactions, which is also subject to the rule. These are restricted transactions. These restrictions cover data access involving vendor, employment, or investment transactions. Unlike prohibited transactions, restricted transactions can be permissible, but only if they adopt very specific compliance, audit, record-keeping measures, along with security controls that are set forth by the U.S. Cybersecurity and Infrastructure Security Agency. Just saying all that, I'm exhausted because this is a really, really difficult one, and I don't blame you for feeling, what in the world did that guy just say? So that is why we're here, to try to help make sense of all of this. So this regulatory landscape that US companies are engaged in is really a difficult one, especially for any global business who engages in cross-border data transactions, and especially those who have a connection to China. It's a big deal for all of those global companies. The DSP also comes with a lot of open questions. Frankly, we get questions daily, if not hourly, relating to what is the enforcement posture? What are the compliance expectations? What is it that I need to do now? What can I do later? And we're really well equipped to have that conversation with two of my colleagues who I've invited to join today's podcast, James Denvil and Lorea Mendiguren. They're both colleagues. James is a partner. Lorea is an associate in the Hogan Lovells Data Privacy and Cybersecurity practice. And they both spend much of their time advising global companies navigating the DSP, particularly in the e-commerce and health life sciences spaces. Lorea, James, welcome to the podcast.
Thank you. Nice to be here.
Thanks for having us, Scott.
All right. So, James, let's start with you. You were on some of the earlier episodes that we did where we covered this topic. And those stages, I think we recorded those maybe back in April or even before that, as the rules were just being essentially finalized. And, many organizations had really questions about what in the world does this thing mean? We've had now several months to digest this. We've been working with this with clients. And frankly, the DOJ has also had an equivalent period of time to start working with what they think this rule is going to be, and frankly, how they're going to implement this rule, because there's a lot of activities that they need to engage in. Maybe before we get into the substance, where do we stand with the current implementation of the rules, and what have been the developments over the course of the past few months as the DOJ has started to signal how it intends to use this new regulatory regime?
Yeah, I think that's really interesting. So at the beginning of the year, I think there are a lot of clients on the business side, and we as counsel advising them were wondering, is this rule really as broad? Did they mean it to be as broad as it seems to have been written? And are they going to take it seriously? Like, there were still rumors that maybe this was a Biden administration rule, so maybe it wouldn't be treated as seriously as others. Some were hoping it would be withdrawn, which clearly didn't happen early on. The first sign that they were going to take it seriously, the DOJ, particularly the National Security Division, was taking it seriously, came in April when they issued some FAQs and a compliance guide. And there were some useful clarifications of terms in that, but the clarifications tended to focus on essentially saying, yes, this is intended to be as broad as you feared that it might be. So the definitions of sensitive personal data really are broad. The types of diligence on your transaction parties that are not US persons is broad. So it didn't give a lot of comfort in sort of thinking, okay, this is manageable. Instead, it seemed to reinforce this is a broad, wide-ranging rule that we are going to take seriously. And the amount of effort that they put into the compliance guide and FAQs, with the FAQs being over 40 pages long, the compliance guide being quite long, showed that they were devoting some resources to doing this. Then last month, towards the end of September, they slipped in another nugget indicating that they are taking this seriously and hoping to recruit others to help them, where without much fanfare, they just slipped in a new FAQ, which was number 106, which isn't even towards at the very last page yet, but 106, how can I report a possible violation of the DSP by another person? And then they have a short, succinct paragraph, which essentially says, well, if you want to be a whistleblower, you can call it the FinCEN Financial Criminal Investigative Unit's whistleblowing hotline, and you may be eligible for a financial reward if the information you provide leads to a successful enforcement action by DOJ. So it indicates that they are incentivizing people to pay attention to DSP, to whistleblow if they identify potential violations, and reminding them that they may receive a financial reward for identifying violations of DSP by other people. There's still some things that are outlined. We haven't seen any enforcement actions yet, at least not that we're aware of. We're still waiting for their list of covered persons. As a reminder, the Attorney General's office through DOJ is supposed to identify a list of covered persons, which could include U.S. entities that they identify essentially to pose threats to national security if they gained access to the types of data you were talking about, Scott. So we still haven't seen those yet. We haven't seen enforcement, haven't seen the covered persons list yet. But it does seem fairly clear that they are taking this seriously and devoting resources to it and trying to recruit people in the private sector to whistleblow on organizations where they identify a violation.
All right, so I hear you saying, James, is that while these rules are now effective, and both phases of the rule, I should say, right? Because we had the initial
Yep.
implementation of both of the restrictions on the data transfers, now all of the related documentation and governance, those also went into effect. And then during that time, the DOJ has not yet had a public enforcement matter relating to these particular rules. But they have been busy. They produced these FAQs. They have been updating these FAQs. I want to get to in a moment, kind of maybe in some places where I've seen that they've issued public letters in connection with, different types of transactions. But before we get to that, one of the other developments, and Lorea, I'm interested in hearing your perspective on this, is that the DOJ is the primary enforcement authority under the DSP. The U.S. Cybersecurity and Infrastructure Agency has a role in being able to promulgate guidance or promulgate requirements from a cybersecurity perspective, but this is really a DOJ rule. Yet we have also seen other government agencies now say, oh, maybe I have some new potential authority under these rules. What were those looking like?
I think what we're really seeing there, Scott, is one of the exemptions for the data security program is for clinical investigations that relate to the FDA. And this exemption it's pretty broad the way that it's framed. There are a lot of ambiguities in how it's going to be applied, but part of the understanding that comes through in the preamble of the DSP is that DOJ is going to have a lot of deference to the FDA to figure out what kinds of transactions are going to fall within that exemption or not. And what we've seen is kind of a response by the FDA and by the National Institute of Health to that exemption to say, well, we're concerned about this as well. What happened is on June 18th, the FDA announced that it is going to review all relevant clinical trials that relied on this exemption to demonstrate full transparency, ethical consent, and domestic handling of sensitive biological materials. And it's specifically, the FDA is not concerned with all transactions, not even with all omic data transactions that fall within the DSP. It's narrowly concerned with trials that involve sending US citizens' living cells to China and then bringing them back to the US. But it's they specifically make reference to that exemption in the DSP. And the NIH does the same thing. They impose this new policy that restricts sharing of human biospecimens of US persons, and they dedicate resources to looking into that. And it shows, even though the FDA and NIH, neither of them are called to regulate in this space by Executive Order 14117 or by the DSP. But because DOJ appears to be deferential to the FDA and these exemptions, they're starting to take action and say, we're taking this seriously too. So this underscores a particular impact from the DSP in the health space. And that's something that we're seeing a lot from clients in that space, is really high effort to assess their agreements and preemptively try to comply as much as possible.
Yeah, and then James, it sounded like the DOJ was also tracking carefully the 23andMe bankruptcy, which had one of the assets or the potential assets in that deal was in a lot of genetic information that may be transferred in connection with the dissolution of the company. What did the DOJ say there?
So the DOJ announced in mid-April of this year, they actually filed a notice in the bankruptcy proceedings informing the court that 23andMe's potential transactions in the bankruptcy proceedings, they may be subject not only to review under CFIUS, but also may be prohibited or restricted under NSD's data security program. So essentially just reminding us like, hey, so you're now in a bankruptcy. Wherever you're going to ship off these assets to, that is going to be potentially a covered data transaction. And it's either going to be a restricted data transaction, which is going to need stringent safeguards, or if it's a data brokerage, which may very well be the case because you're selling an asset, a data asset, to an entity that did not collect that information directly on its own, that would be a prohibited transaction, particularly with the types of sensitive personal data at issue here, where it's genetic data.
All right, so I'm convinced lots of stuff's going on, and my guess is that we're really at the very beginning of this journey than we are close to the end of this journey. And so I think it's important for, everybody who is in this space and is responsible for helping guide their organizations in a way to meet these requirements and to kind of achieve their compliance goals is to try to understand where we are seeing these big issues come up. And I first just want to make sure we are underscoring the breadth of this, right? Because this is something, James, you were mentioning in your response a moment ago, just how broad this looks like. And maybe if I am kind of just trying to say, who needs to be concerned with this? And maybe I'll throw out a couple of ideas, appreciate both of your perspectives on how maybe you think about it. But I think if you are a business who has personal data, and you have any type of connections into either your own internal infrastructure with connections into a country of concern, namely for this purpose, we'll say China, or you have connected to a supply chain that has a connection to China, then you have to worry about this rule. Do you think I'm off on that?
No, I don't think you're off. And I think a surprising thing for me, and I think for some businesses, is to realize it goes even broader than that. So if you're thinking about countries of concern and you're just focused on China, Russia, North Korea, Cuba, Venezuela, and that's where your gaze is, you might then not think, when you see that maybe you're thinking of going into a joint venture or you're a startup and wanting to get some angel funding from an individual investor, let's say, who happens to live in France and they're a Canadian citizen, let's say. They're not a covered person or a country of concern, just if you see that there's no direct connection to China or to North Korea or Russia. However, they're a foreign person, and if they happen to be employed by a covered person or a country of concern, so a company established in China, let's say, then an employment could include being on a board of directors, doesn't have to be a strict employment relationship, then you're engaged in a covered data transaction. So I think that's where the surprises are. Certainly, if you are aware of any nexus or connection to those countries of concern, you have something to potentially worry about. But essentially, if you're engaged in any transaction with a foreign person, you may have things to worry about, even if those foreign people or foreign entities are not directly associated with China, Russia, Hong Kong, et cetera.
That's exacerbated, I would say, Scott, by the breadth of the actual terms and definitions in the DSP. So take access, for example. Access means both the possibility of accessing and actually accessing. Just being able to potentially tap into that data is enough to trigger the rule. So that expands the whole universe of the types of data that are covered, not to mention, as you mentioned in your opening, that there are categories of data that are very commonly being collected in regular, everyday global transactions. These include demographic information, contact data, advertising IDs, device identifiers. All of that is going into making this rule a really broad, casting a very wide net.
So that goes to the question I was just about to ask you, Lorea, because, the rule, I think many people still refer to it as the bulk sensitive data rule. If I'm a business, I'd say, well, I don't really have data in bulk. I'm not one of these companies who just harvests large amounts of data. And the data I have is not particularly sensitive. Maybe I'm just collecting information about people who visit websites. So I'm just getting IP addresses and I'm circulating those back to advertising IDs. That is how the ad tech system works. This is not sensitive information, nor is this something that is in bulk. Maybe then I don't have anything to worry about.
Might still have something to worry about. One thing is the way that bulk, keeping in mind how the bulk measure works. This applies to, there are two types of data that are covered by the DSP. There's US government related data, and that is information, location data, or maybe data about personnel in general, that any amount of it is going to trigger the DSP. So government related data is kind of its own bucket. The bulk threshold applies to sensitive categories of information as defined by the DSP, which go pretty broad. And the bulk thresholds are different for each type of category of data. So it's immensely important as a company to understand what kinds of data you're really transacting in to see if you're hitting those bulk thresholds. If you are engaged in transactions involving omic data, that threshold is really low and easy to hit. It's only 100 US persons, and you've already exceeded that bulk threshold, and the transaction falls within scope of the DSP. Other categories also have very low thresholds that are quite quick to hit. Precise geolocation is 1,000 US persons, biometric data, same thing. The broadest category for covered personal identifiers, which has some of those really common types of data, does have a higher bulk threshold of 100,000 US persons. But in the ad tech world, that can be easy to hit pretty quickly. So it's important to be monitoring how those numbers are starting to add up. And the measure is over a 12-month rolling period. So in any previous 12 months, if you have transacted in over 100,000 US persons worth of data for covered personal identifiers with one transaction party. So the bulk thresholds apply to specific transactions with transaction parties. You can have transactions that are under bulk thresholds with multiple different entities. That's okay. But if you hit bulk thresholds with one transaction party, that's going to trigger the DSP.
So, James, Lorea is making a convincing point that these terms are really broad, but I think maybe we can all take some comfort in the fact that it's all subject to a knowledge qualifier. So if I engaged in a transaction, but I didn't know that that data would become accessible to China, or I didn't know this was the sensitive data that would have been subject to these rules, then I should be in the clear, right?
Well, yes, except for the horrible lawyer's caveat of it slightly depends. So, as a general rule, it is a knowledge-focused requirement. And if you know that you're engaged in a transaction and you know that it's a prohibited or restricted transaction and you haven't run through the traps of assuring that there's an exemption or a license or the proper safeguards, that's a violation if you know. But the mere fact that you don't know isn't necessarily a safe harbor. For example, there is some helpful guidance in the compliance guide that came out from NST stating that if you're transacting with a US entity, so it's a US to US data transaction, you generally don't need to do a deep dive into their employment practices or their vendor practices to see if there's going to be an onward transfer to a country of concern or a covered person. However, there's plenty of guidance out there and examples within the rule that talk about whether you should have known. So although it is a knowledge standard, it's a know or should have known. So for example, if you're engaging with a US entity, an entity that you think is a fully US entity, but you find yourself having to schedule all of your calls with this vendor to meet a Hong Kong time zone, that might establish that you should know that this data transaction involves potential access by individuals who are based in China and potentially covered persons. So some reasonable level of diligence is required, and you can't just turn a blind eye to indicators that you are engaging in a covered data transaction.
And if, the government here kind of follows its historical pattern, my guess is that they will have a broader notion of what companies should know versus maybe what those companies feel like they should know. And that then really creates this question around, well, what level of diligence that an organization needs to perform to meet the standard of whether they should have known something. And Lorea, I think they create a framework here, right, around how companies can approach that question.
I think we can piece together from the preamble, from the guidance materials that they put out, we can piece together what it is that DOJ expects US persons to know. So what is automatically within that reasonable knowledge caveat? And I think that we can break that down into three categories. The first is know your data. DOJ expects companies to understand the types of data, the quantities of data that they're making accessible to counterparties. So if you're engaged in transactions involving covered data, that's something DOJ expects you to know. The second one is know your counterparties. This means that US persons should be assessing whether counterparties to covered data transactions are covered persons or countries of concern. And there are many ways that you might do this, but one thing that DOJ really emphasizes is check the covered persons list. This hasn't been made available yet, but the National Security Division will be posting a covered persons list, and that's part of the diligence that they're expecting. And then some, whatever mechanisms you use to verify the ownership of a company. A lot of entities that engage in global transactions have export compliance teams that might be looking into this. Make sure that the counterparty you have that's accessing covered data is not a covered person. That's something that should be involved. And then the third point is know the purpose of the data access and the transaction. You should know if the transaction you're engaging in, DOJ believes, is data brokerage. And the other important aspect about knowing the purpose of your data transaction, and the reason that we really recommend that, is it's valuable when you start thinking about the exemptions as well, which are really limited to specific purposes. So understanding why that access is being granted will help you assess if you fall into an exemption or if you might not.
Yeah, I think a really kind of helpful framework, at least for purposes of trying to create a plan about how to approach this. As you're noting, there are many aspects of what the rule system and the framework is going to eventually require as part of the overall DSP, which we don't yet have visibility into. That would include areas surrounding the restricted party list, the licensure list, the ability of seeking formal advisory opinions. All of those I think are TBD. But in the same breath, we are in the position where enforcement is possible. And because these rules are currently in effect, and James, maybe importantly, maybe it's worth noting, what is the consequence of getting this wrong?
So the consequence of getting this wrong, if it's just sort of an unintentional violation, so not knowing or willful, is that you're going to face damages of the maximum of 330 some odd $1,000 or twice the value of their transaction. Now, they haven't built into the regulatory framework how they're going to calculate the value of the transaction, but there's case law out there from other frameworks, particularly in trade issues, where the value of a transaction will be viewed broadly. It may not be just the amount of money that's been changing hands, but it could be they will look at financial indicators of what the value of this particular transaction is to the organization, the revenue that they are able to generate from the transaction, the investments that they're able to generate from the transaction, et cetera. So that could be a large number, even though at first you just look at it and say, oh, it's just, a little over $300,000, but it could be twice the value of the transaction, which for a large data transaction, that could be a large amount. But then there are potential criminal penalties as well. So if there's an intentional violation, knowing and willful violation, you're looking at up to 20 years in prison and $1 million in liability. And so that would be on an individual basis that it could be attributed to. So individuals who are responsible for their data transactions to be aware that there are potential criminal penalties if they're intentionally engaging in covered data transactions in ways that do not align with the requirements of the regulation.
Yeah, and importantly, James, when you're referring to data transactions, we are thinking about transactions that involve data, not that the data itself has to be the subject of the transaction. So
correct.
Yeah. There is an investment relationship, for example, which could be a sizable investment, which results in the potential access to data by that investor. We're looking at the total size of that transaction and the investment and the proceeds coming from the investment, not just any type of attribution of the value of the data associated with that transaction.
Absolutely.
Okay. All right. Well, then I have what I'm hearing is this is very broad. It is in some ways uncertain. It is very difficult to be able to get your arms around about what the scope of this. And at the same time, I have potential civil and criminal liability for getting it wrong. So if that doesn't scare you, then you probably need to rewind more back to the beginning of the podcast and hear that one more time, because it should. But at the same time, we're not, at least in the business of shutting down global commerce. And so basically saying, okay, hey, you can no longer operate in and out of China uh, that is not what we are collectively looking to do. We're looking to figure out how is it that we can create solutions to be able to address the compliance challenges that this rule comes up, address the underlying policy that the United States has set out under these rules, but in a way that we can be able to facilitate business while meeting these particular compliance requirements. And in some ways, we've done this before. And we have, for a very, very long time, have been dealing with one, cross-border data transfer restrictions, namely the ones that have been adopted by the European Union and the United Kingdom and Switzerland, and a number of the other countries that have more recently adopted cross-border data transfer restrictions. And then second, we've also been dealing with data localization laws for a very long time. And those have come in a variety of different flavors. So while the DSP itself is a new policy in the United States, and unlike really anything that we have developed, at least in the data side, we've seen parallels maybe in OFAC or in sanctions-oriented, export control-oriented laws, but in the data world is novel. It is not a novel set of policies around how is it that we are going to comply with them, because we have a lot of experience in doing this. So I guess maybe my first question, James, and just in terms of practice points here, how are companies approaching compliance with this right now? Call it the immediate steps of action items. Say you had an organization who is just now fully understanding what the scope and complexity of these requirements look like, and they need to do something. Where do they start?
One of the first things I'm seeing is starting to the extent that they have not done so already, to address other compliance requirements, either developing or refining their data inventories to focus on classifying where there might be bulk US sensitive personal data. A lot of organizations aren't dealing with the government related data, but they may very well be dealing with the bulk US sensitive personal data. So one of the first things to do is figure out where is that data. Then starting from there, figuring out, okay, now at a risk level based on the core vendors, who are we providing access to that data, and assessing whether there might be any covered persons under there. So it's really at the initial stage, at least some kind of data inventory and data access inventory. Then some other steps are developing some template contract provisions if they're going to be engaging in data brokerage transactions, or just for any vendor agreement to plug in some language that will help you establish that you did not know that there was going to be any onward transfer because your contract prohibits your vendor from sending the data off to a covered person or a country of concern. And then also some M&A or transactional playbooks and diligence guidance that helps the teams that are working day to day on those transactions identify where there may be some hurdles that they may need to address, and identifying risks associated, particularly when you're engaged in a transaction that involves foreign persons, and figuring out how far deep you have to go into that, company list and the hierarchy to figure out whether any of those transaction partners might end up being covered persons. So a little bit of data inventory work, triaging it, prioritizing it by risk, particularly in terms of the bulk level of the data, and then taking some steps on your vendor agreements and any transactions you're engaging with to develop some template provisions and some playbooks there.
So all, I think, really good points, James, and I agree with all of them in terms of where a lot of the action has been to date. Many of those are going to go really to call it what I would think of as more phase one of these compliance obligations, in particular to try to understand what transactions you may engage in that would be qualify as prohibited or restricted, and then importantly, what types of things you need to do to be able to address those transactions. Now I think we're in this next phase here where there is actually an associated requirements to obtain develop a governance program that would allow for the documentation of your compliance, having a process by which you are evaluating and auditing your compliance, having a mandatory reporting obligations. Maybe Lorea, you want to talk a little bit about what the scope of that looks like?
Importantly, most of these additional reporting and record keeping obligations specifically apply to restricted transactions. So I think that's where we're going to start getting into that second phase. Right now, we're seeing a lot of clients focused on the diligence aspect, how they can assess the transactions that they have. And one of the questions we see them grappling with is if they see a transaction that could potentially pose risk, does it make sense to proceed with it as a restricted transaction and comply with all of those record keeping, reporting, and CISA security requirements? Or does it make sense to try to rearrange the transaction, fix it so that access is not granted to begin with, or just go with a different vendor? So we're starting to see that split happen. And I think phase two is going to arise a lot when companies realize we have restricted transactions going on here. We can't just undo them. They exist restricted as they are. And we need to actually start implementing now the record keeping requirements, making sure that we're retaining records relating to these transactions for 10 years, making sure that we're reporting any transactions that involve cloud computing and are subject to these annual reporting requirements, making sure that if we receive an offer to engage in a prohibited transaction, we're making that report to DOJ, implementing those kinds of now full compliance measures, as opposed to phase one, which I think was a lot of that diligence, that know your data, know your transaction party, know your purpose. Now we're moving into, okay, I'm recognizing that I have transactions that fall into this rule. How can I build out that robust record keeping, reporting, and compliance and security program?
Yeah, I think that's exactly right. That's going to be the emphasis. But I think it's even maybe, another nuance here that is often overlooked is that those keeping requirements and kind of that governance process that you're describing apply for restricted transactions. But some of these rules are going to apply regardless of whether there is a restricted transaction or not. Namely, maybe kind of coming up to the top of that list is the mandatory reporting requirement. Because like, sanctions laws, there is an obligation to engage in a reported transaction to the DOJ, maybe in some circumstances that would not be immediately obvious. James, what does that reporting requirement look like?
So the reporting requirement is for data brokerage transactions. So if you receive an offer to engage in a prohibited data brokerage transaction, you need to report that to DOJ within 14 business days. Now, that doesn't mean that the individual knew that it was a prohibited data brokerage transaction, but the issue could just be that some entity, foreign entity, let's say, that's not fully aware of DSP, maybe they're a vendor or they're some kind of advertising agency or the like, approaches you and says, we'd love to help you out with your marketing, let's say, and we can maybe supplement the data that you have for better marketing, better lead generation and the like. But that's going to involve potentially a sale of your data to that entity. Now, you may have no interest in engaging in that transaction. Maybe you just receive a cold email or a cold call offering to engage in this transaction. You need to report that within 14 business days. Now, as we said earlier, talking about what is the mens rea for this regulation, it's whether you should have known about the transaction. Now, if one of your salespeople receives one of these offers, is that going to be attributed as your organization now knowing that it received an offer? And as you mentioned, Scott, typically in hindsight, that what you should have known tends to be a lot broader than what we think of sitting right here on day one, looking forward. So there needs to be some training out there and some education with the types of individuals who typically receive offers for transactions within your company to educate them about if you receive this kind of offer and there's any kind of indication that it's from one of these countries of concern or a covered person, there may be some reporting requirements. We haven't received perfect guidance on this from DOJ yet, but I think that's a broad area where organizations need to start figuring out how do we train our workforce to identify these offers of quote unquote unlawful transactions and where they need to report them within the organization so the organization can then file their reports with DOJ.
I agree with that, James. Maybe, and I would push you even a little bit further because it's not only that we are in a position where we have to train our workforce, how is it that they need to identify when this happens so that we can associate report them? but it's almost like they have to be trained not to engage in any type of conversation that may be then attributed to an offer, right? Because as you can imagine, you have two non-legal people sitting in the same room from two business partners, and they're exploring all such different types of business operations and ideas and synergies. And some of those may look like data brokerage transactions. They're not really described that way in the way that people are referring to them. But all of a sudden, they come back and maybe everyone doesn't sense an issue. They go back to legal and they say, hey, legal, can we do this? And legal's like, no, that would be a prohibited data transaction. Now, do I have a situation where because two business people acting in good faith were just strategizing on what a business opportunity would look like that ultimately resulted in a proposal or an idea for a prohibited data transaction that I need to go to the DOJ and tell them about that?
Arguably, you do.
Yeah. Now, again, if that doesn't scare you, I would want you to go back again to the beginning of this episode and just understand, like, what is the significance of this thing? Because we are now in a position of figuring out we have really broad requirements. We have really difficult obligations to comply with for any global business, civil, criminal penalties, and potential auditing, and the ability for mandatory notification requirements. Yikes. Well, James, Lorea, really appreciate your time and sharing your expertise and experience on this episode and with our audience. I am sure we will need to have you back on probably regularly as continued updates, are expected for this, and as organizations continue to try to map their efforts toward compliance.
Thank you, Scott.
Yeah, thank you. We'll be on the lookout and we'll report back.
We'll stay tuned.
With that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.